Thank you, Ludovica. Thank you, Maria Rosaria, for inviting me today. It's a pleasure to be here. My presentation is slightly different from the previous ones, as it takes a pure international law perspective. That's my background, so bear with me if I deal with black letter law and I try to apply them to a new situation like that of cyber context, the cyber context. There you go, it works. It is relatively uncontroversial that the law of armed conflict, which is my field of specialization, the law of armed conflict applies if cyber operations are conducted by belligerents against each other during and in the context of an armed conflict. Be that armed conflict an international or a non-international one. A good number of the rules of armed conflict deal with targeting. They will establish what is lawful to attack and what is not. The main principles of the law of targeting are the principle of distinction. You can never directly, intentionally attack civilians and civilian objects. Attacks may only be directed against combatants and military objectives. This is the first and most important principle of the law of targeting. The second principle would be the principle of proportionality, and the third principle is the duty to take precautions when you conduct an attack. I will be looking only at one of these principles for obvious time reasons, which is the principle of proportionality, although I will also mention the duty to take precautions, if only incidentally. What am I talking about? What is the principle of proportionality? The principle of proportionality is codified in the 1977 Additional Protocol 1, additional to the 1949 Geneva Conventions on the protection of victims of war. As you can see, it's not mentioned, the word proportionality is not mentioned there as such, but it's commonly referred to as the principle of proportionality for the reasons that I will try to explain later. The text of Article 51, paragraph 5b is there. An attack is indiscriminate and therefore prohibited if it may be expected to cause incidental loss of civilian life, injury to civilians, damage to civilian objects, or a combination thereof, which would be excessive in relation to the concrete and direct military advantage anticipated. This principle is settled. It's generally agreed. It's not only codified in a treaty, it also reflects customary international law. It's therefore binding on all states, whether or not they've ratified Additional Protocol 1. And it's also generally accepted that it applies not only in international, but also in non-international armed conflicts. So the problem really is not the if this principle exists. The problem is the how it applies in traditional warfare, and even more, how it applies in a new context like that of warfare in cyberspace. You can see, for instance, that the final report of the ICTY Committee on the NATO bombing in and against Yugoslavia said very clearly that the main problem with the principle of proportionality is not whether or not it exists, but what it means and how it has to be applied. Now, it is therefore not disputed that the principle of proportionality would amount to cyber operations in the context of an armed conflict by a belligerent against another belligerent, but only if those cyber operations amount to attack. That's the first word that you can see there. An attack is indiscriminate if, etc., etc. So, not all cyber operations would be limited by the principle of proportionality in armed conflict, but only those cyber operations that amount to attack. And attack is a term of art. Okay, it's a technical language that is defined by Additional Protocol 1 itself in Article 49 as acts of violence whether in offense or in defense. So, again, the principle of proportionality and the law of targeting in general would apply only to cyber operations when they are acts of violence, whether in offense or in defense. Non-violent military harm is not sufficient to turn an act of hostility into an attack, not according to Additional Protocol 1. When is a cyber operation an attack, then? When is it an act of violence? Again, I think it's relatively uncontroversial. It's also the solution adopted in the Tallinn manual, adopted a couple of years ago by the CCDCOE. It is those cyber operations that employ means and methods of warfare that are resulting or likely to result in physical damage to persons or physical damage to property, loss of life, injuries, etc. So if you think, for instance, of Stuxnet, which I believe was already mentioned this morning, if you think of Stuxnet, assuming, and obviously that's not the case, assuming that it had been conducted by a belligerent against another state in the context of an armed conflict, Stuxnet would have qualified as an attack because of its alleged consequences on the gas centrifuges at the Natanz uranium enrichment facility. So there's no really, at least not among international lawyers, there's not really a huge debate on whether cyber operations resulting in physical damage are attacks in the sense of Additional Protocol 1, and therefore whether the law targeting applies to them. It's more complicated to establish whether disruptive cyber operations that cause a functionality loss without actually damaging the infrastructure they attack also qualify as attacks, also qualify as acts of violence. Again, if you take the Tallinn manual, you'll see that they take the solution that these are not attacks in the sense of the law of armed conflict, and therefore the law of targeting does not apply to merely disruptive cyber operations. I tend to disagree with that, although I try to keep an open mind in relation to these issues as much as possible. I tend to disagree with that solution, and I think that at least certain disruptive, again, merely disruptive cyber operations are also attacks in the sense of Article 49 of Additional Protocol 1. Because I think that that definition of attack, acts of violence, has to be interpreted in a dynamic way, in a dynamic manner that takes into account the technological developments of recent times. And therefore the notion of violence should perhaps, and obviously with the consequences it has on protected persons and objects, should be expanded in a way to incorporate new means of causing damage to those protected persons and objects. And if you look, if you read around, this is already suggested by some states. For instance, Panama, in its views submitted to the UN Secretary General, states are regularly asked by the UN to submit their views on cybersecurity. Panama said that cyber operations are a new form of violence, and I quote from their statement. And to me, again, it makes sense in the sense because if you take into account the dependency of modern societies on computers, computer systems, and networks, well, you realize that it is possible now to cause significant harm through non-destructive means. Of course, I'm not talking about inconvenience. I'm not talking about stress. I'm not talking about the fact that you may or may not access Facebook at a certain point of time or tweet about what we are saying here at this conference. I'm looking at the severe incapacitation of critical infrastructure. I'm looking at something which is it has more than transient or merely inconvenient effect. I'm looking at something that actually significantly affects the functioning not of any infrastructure, but the functioning of critical infrastructure. I do not see why, again, disabling them, what really matters at the end of the day is the fact that they are rendered inoperable, whether it is by physical or non-physical means. So the question is how the principle of proportionality would apply to these cyber operations, to the cyber operations amounting to attacks. And as you can see from the text of the provision, just on my slide, you'll see that there are two parameters that have to be balanced. It's a balance between two different values of different nature. One is the incidental damage on civilians and civilian objects, or their combination. And the second one is the concrete and direct military advantage anticipated. The one must not be excessive with respect to the other, for the attack not to be indiscriminate. So you are entitled to attack a military objective even if this results in incidental damage on civilians and civilian objects. But these incidental losses cannot exceed a certain amount. Otherwise, the attack becomes unlawful. Okay? So incidental damage, loss of lives, of civilian lives, are perfectly allowed, cynical as it may be, according to the law of armed conflict, but this must not be disproportionate with respect to the military advantage you're seeking by conducting that attack. The question is, what does incidental damage, what does damage mean? And what does military advantage mean? What do you put in those notions in a cyber operation amounting to attack when they are applied in the cyber context? I will first look at the first element, the incidental damage on civilians and civilian objects, and then I will look at the concrete and direct military advantage, and then finally I will try to balance them against each other to see if there is a way of doing it. So, starting from incidental damage on civilians and civilian objects, it is probably well known that there are different orders of effects that a cyber operation can cause. First of all, you have what we may call primary effects, those on the data or the software attacked. Then you have, if you do, not necessarily, secondary effects, those on the infrastructure operated by that system, if there is such an infrastructure, as in the case of the SCADA systems. And then you may have tertiary effects, those on the users of the attack system or infrastructure. Now, in my view, all the three orders of effects should be calculated, should be counted in the notion of incidental damage on civilians and civilian objects. Again, this is not particularly new. This is not something, a revolutionary finding that was made in relation to cyber warfare. The fact that also some indirect effects have to count in the proportionality calculation is already present in certain military manuals, not necessarily in relation to cyber operations, like the US counterinsurgency field manual, for instance, or the US Commander's Handbook on the Law of Naval Operations. Recently, this point was also made, now it's 2 years ago, in the speech that the US Department of State's legal advisor gave at the US Cybercom in 2012, where he clearly said that you have to take into account also when you decide whether you can target by cyber means a certain objects, whether you have to take into account also the effects on the infrastructure that this system operates and on the users that may be affected by the loss of functionality of that infrastructure. So, primary, secondary, and tertiary effects. Primary effects, as I said, are those on the data or the software, which is being corrupted or altered by the malware. It's probably we have to be careful with this. There's a big question on whether, for instance, data are objects and similar questions in this context. The mere corruption of software and data without physical consequences is probably damage in the sense of the law of armed conflict, probably only in exceptional situations. For instance, when we are looking at data that are convertible into objects, or even perhaps more clearly in the case of digital art. In all other cases, especially if the cyber operation only destroys data without physical consequences be they disruptive or destructive, it wouldn't be a cyber operation amounting to attack. It wouldn't be an act of violence. Therefore, the problem of proportionality, the application of proportionality to the cyber operation would not arise, whether or not we consider the damage to data damage in the sense of Article 51. As to the secondary effects, the effects on the infrastructure operated, if there is one, again, it's not always the case, operated by the attack system, it's not just the physical damage to that infrastructure, but it is also the loss of functionality of that infrastructure, however reached, however obtained, that should be counted in the proportionality calculation, and in particular in the notion of incidental damage. I find it counterintuitive that it should only be the physical destruction of the physical object that should be taken into consideration. When you think that functionality loss could actually affect, certain at least functionality losses, can affect the civilian population much more severely. Therefore, again, I'm not talking about inconvenience, I'm not looking at irritation or fear created by a cyber operation. What I'm looking at is the incapacitation of network infrastructure that may have potentially as severe effects on civilians and civilian objects as certain kinetic attacks. So again, what matters is the fact that this infrastructure is rendered inoperable by the cyber operation. It doesn't really matter how. Therefore, the targeteers, when they are trying to decide whether they can or cannot undertake a certain cyber operation in the context of an armed conflict, should take the consequences into account, the consequences arising from the loss of functionality of dual-use infrastructures caused by cyber operations amounting to attacks. The fact that these cyber operations can be used to incapacitate instead of destroying infrastructure has been used by some commentators to argue that this might actually expand the scope of what is targetable. The fact that you do not necessarily destroy the target, you simply disrupt its functioning without physically damaging in certain cyber operations, has pushed someone to suggest that therefore you could also attack objects that would normally be illegal to attack, like objects that only indirectly contribute to military action, or objects the neutralization of which offers a non-definite military advantage. But this view, I strongly disagree with this view, and I'm obviously not alone on this, because this view again disregards the fact that the disruption of certain infrastructures can actually cause, in certain cases, far more serious effects on protected persons than certain kinetic attacks. And there's nothing really in the law as we have it that distinguishes the legality of attacks depending on the means or the effects on protected persons. So the definition of military objective applies regardless of the means of the attack. Therefore, objects that are not military objectives for the law of armed conflict are and remain civilian objects. However, certain attacks against military objectives that would be unlawful if conducted by kinetic means because they would breach the principle of proportionality, causing excessive incidental damage, may become lawful if conducted by cyber means, in the case that that incidental damage is reduced because of the cyber means used. But again, we are still looking at attacks against military objectives. Again, on incidental damage, one last point. The last point is that the incidental damage will, if you are a targeteer and you're trying to establish how much incidental damage you're going to cause, you will also have to look beyond the system attacked. Because like with biological weapons, there is a good chance that the malware will spread to other computers and will damage those systems and will potentially damage the infrastructures that those systems also operate. So in a cyber operations that shuts down, for instance, a dual-use power station, you will have to take into account not only the loss of the civilian function performed by the installation, with consequent repercussions on the civilian population and that used the electricity produced by that power station, but also the fact that the malware may spread to other systems. from this point of view, probably the only indiscriminate cyber operation by definition would be a denial of service attack, which simply floods the targeted system with requests and does not employ malware that would necessarily potentially spread to other systems. Let me move to the second element of the equation, which is the concrete and direct military advantage anticipated from the attack. The keywords here are concrete and direct. So it's not any military advantage that justifies incidental damage on civilians and civilian objects. It is only the military advantage that is concrete and direct, which means substantial and relatively close. It's not something hypothetical or not directly linked to what's going on the battlefield. Obviously, we may have a problem here because if you interpret concrete and direct as a real quantifiable with precision, with exact precision, we may have an issue here with the measurement of effects of cyber operations, which can be difficult to do before the operation actually is conducted. Again, to keep to the Stuxnet Stuxnet example, is still unclear how much damage Stuxnet caused. If it caused any damage at all, if it damaged 20% of the centrifuges, if it was more than that, there are different versions. If that damage was caused by Stuxnet and not rather by technical malfunctions of the facility itself. So it may be difficult to establish, to measure the effects of the cyber operations, not only, as I said, before the operation, as in the case of Stuxnet. According to the ICRC, the International Committee of the Red Cross, which was mentioned this morning, which is the guardian of the law of armed conflict, military advantage, concrete and direct military advantage, means ground gained, annihilating or weakening the enemy armed forces. Okay, it's nothing more than that. It is something, as I said, is directly linked to what's going on the battlefield. This is the ICRC's view. However, there are states that are reluctant to accept such relatively narrow notion of military advantage, and they expanded up to include also the protection of the attacking forces. That's the case of Canada, for instance, Australia, New Zealand, Israel as well. If this is correct, if concrete and direct military advantage also includes the protection, the increased protection of the armed forces, of the attacking forces. Obviously, in this case, cyber operations are very good. They certainly increase the concrete and direct military advantage because of their remote character. They present basically zero risk for the attacking forces. And therefore, if the concrete and direct military advantage is higher, because it includes the increased protection of the attacking forces, the incidental damage is also higher because it has to be balanced against that. You increase one, the other one may also be increased. Again, I tend to disagree with this view, and I tend to agree with the ICRC's view. After all, the number of states that have supported this broadened notion of concrete and direct military advantage is relatively limited. And this view, this broadened notion of military advantage also presents a major disadvantage, which is that of introducing a further subjective element in this calculation, which is already, as I'm sure you've realized already, which is already subjective enough. So, for instance, what is the value of the safety of military personnel with respect to civilian lives? Does it depend on their rank or their specialization? What is the value of, for instance, protecting military materiel as opposed to military personnel? So I think again, concrete and direct military advantage should not be extended to include the protection of the attacking forces. However, it can be taken into account in the context of the duty to take precautions. When attacking a military objective, the belligerent states have to adopt certain precautions against and in attacks. And one of these precautions that should be adopted according to additional protocol 1 is the fact that they should take all physical precautions in the choice of means and methods of attack, with a view to avoiding and in any event minimizing incidental loss of civilian life, injury to civilians, and damage to civilian objects. So in my view, it's clear that feasible in this context, all feasible precautions in the choice of means and methods of attack in order to minimize or avoid civilian losses and damage. Feasible also includes the protection in this context of the increased protection that the attacking forces may gather by using a certain means or not. After all, the attacking forces are under no obligation to sacrifice themselves. And this is clear, for instance, if you read the UK military manual. The UK military manual clearly says that a commander needs to evaluate the risks to his own troops when he evaluates the choice of means and methods of attacks. Therefore, a targeteer may go for a certain means or methods of warfare, including cyber operations, that minimizes the risk for the attacking forces, and even if this is to the cost of reducing the military advantage he anticipates, but providing this does not increase the expected incidental damage on civilians or civilian objects. One last point on concrete and direct military advantage. When the cyber operation amounting to attack is composed of multiple hostile acts, the military advantage has to be established, has to be assessed in relation to the operation as a whole. This is an interpretive declaration which was submitted by the NATO states when ratifying additional Protocol 1. So the attack has to be considered in its, the attack, not the war. The attack has to be considered in its totality and not in its specific parts. So, for instance, there have been claims that in 2007 Israel conducted a cyber operation, disruptive cyber operation that shut down the radar system of an alleged nuclear facility in Syria. In the following days, this nuclear facility was bombed. I think the code name for that operation was Operation Orchard, but I may be wrong. My point is that the military advantage of the cyber operation that preceded the kinetic attack on the nuclear facility has to be assessed jointly with the subsequent kinetic operation, of which it was a component. Now, assuming that it's clear what concrete and direct military advantage and incidental damage on civilians and civilian objects is, we have to try to balance them against each other, because remember, one must not be excessive with respect to the other. Now, the keyword is excessive, okay? It's not extensive. The principle of proportionality does not prohibit a cyber operation that incidentally causes extensive damage on civilians and civilian objects. It's not prohibited because it is extensive. It is prohibited, if it is, because it's excessive with respect, because it's not justified by a corresponding concrete and direct military advantage anticipated. For instance, a cyber operation that disrupts some military electronic systems in a minor way, but at the same time causes irreparable damage to the civilian infrastructure, like water management or stock exchange, this is probably excessive in the sense of Article 51, paragraph 5. However, and this is a further problem with calculating proportionality, is the problem is that it is not really the concrete and direct military advantage or the incidental damage that actually occur that you have to balance against each other. You have to balance the expected incidental damage and the anticipated military advantage. which means that you have to guess. You have to guess on the basis of all the information that you have to diligently try to collect at the best of your capacity before the attack. Okay, but it is still an evaluation that occurs before the attack takes place, and therefore it is predicting what the concrete and direct military advantage will be, what incidental damage on civilians and civilian objects you will cause. And this is already, as you can surely understand, this is already difficult in a kinetic environment. It is incredibly difficult in the cyber context, where you have to take into account also the interconnectivity of networks, the potential reverberating effects, the measurement difficulties in measurement of effects, etc., etc. So the balancing process also increased by the moment in time where you have to do it before the attack is by its own nature a subjective process. It's by its own characteristics a process where your background, your job, your personal views on certain issues, so will necessarily play a big role. So what is excessive incidental damage caused by a certain operation, be it kinetic or cyber, in relation to the concrete and direct military advantage anticipated? If you ask this question to a human rights lawyer or to some member of the military forces, they're probably going to give you different answers. And this is why the ICTY first, and then also the ICTY committee established to review the bombing campaign in Yugoslavia, came up with this character, the reasonable military commander, who, however, sits between the human rights lawyer and the military officer, which has only military necessity in its mind, in its concerns. This reasonable military commander, I think, in the cyber context will necessarily, because of the technicalities of the cyber context, I think will necessarily have to be assisted by cyber engineers, so unless he's a cyber expert himself, in order to properly evaluate the consequences of the cyber operation. Collecting information about the architecture of the attack network or of the operating system will also be of decisive importance for a reasonable military commander, because the damaging effects of a cyber operation will greatly depend on the characteristics of the targeted systems. So all in all, the issue is one of degree. If the effects of a cyber operations are entirely unclear and unforeseeable, or greatly unclear and unforeseeable, then the attack would be likely indiscriminate and therefore prohibited. So, what are my conclusions on the application of the principle of proportionality in the cyber context? My conclusions is that there are, perhaps it's a diplomatic conclusion, there are advantages and disadvantages. There are opportunities and dangers for the principle of proportionality. On the one hand, cyber operations are potentially less damaging and therefore may be a better means to cause less incidental damage on civilians and civilian objects. And cyber operations also present advantages for the attacking state because of the increased, as I said, the protection of its forces, because there's hardly any risk that they encounter because of their remote character and the difficulties in identification and attribution. On the other hand, and that's if you want the dark side, the interconnectivity of military and civilian networks raises the question of the spreading of malware, which may be difficult to predict and therefore to avoid or minimize. And that's where the third principle in targeting, remember the duty to take precautions, again plays a major role. All feasible precautions must be adopted by the attacker to ensure that the attack is consistent with the principle of proportionality. again, although it wasn't in the context of an armed conflict, and therefore the rules I'm talking about did not apply to it, it seems that those that developed Stuxnet, if they were state, but again, I'm not looking at, I'm not trying to apply these rules to Stuxnet. I'm just giving Stuxnet as an example of a cyber operation, whoever was responsible for it, where some, if you want, proportionality concerns were present. The risk of the possible spreading of the malware to other systems, etc. If you think that it was a worm that was activated only by the presence of that specific Siemens software that were used at NATO, and so the fact that I read in reports the worm only spread to each time to other 3 computers, and the fact that the worm would deactivate itself on the 24th of June 2012. So there was obviously a concern on minimizing the risk of incidental damage, which, if it had been committed in the context of an armed conflict, and these rules I was talking about did apply, would have perhaps avoided the indiscriminate character of such an operation. I think I'll stop here, and I'm, yeah.
Thank you very much.